Good evening, one and all. Thank you, Sir Fisher, for being here for my class or the session. Today, what we are going to discuss is another part of patent law that is known as compulsory licensing. As far as India is concerned, as you might already know, there is only one instance of compulsory licensing. That is what you call a dispute, and that's a transaction between an Indian company called NATCO and another company called Bayer, which is a German pharmaceutical giant. So this is the story which we are going to discuss today. And let's start with the basic. Patent law, as all of us know, is an exclusive right. It's an exclusive right in respect of an invention. It is intangible, and all those are known to us. And let us look at the rights available in respect to patents. The rights available to a patent holder, as we discussed in the previous classes, the rights available are the right to make, use, offer for sale, sell or import the product of the invention. The product of the invention. That's what. Okay. So these are in a way the interests which we can call as business interests, which are quoted with legal skin, you can say. So it's an exclusive right. It is a legal monopoly. That's what we can say. And when there is a monopoly, there is a chance of abuse of monopoly. In fact, if you look at very many case studies about patents and chances of monopolization and abuse of patent, there are very many instances, in fact. So the mechanism of compulsory licensing is a mechanism where when there is an abuse of patent monopoly, the law comes in, or a legal institution or a government authority steps in. That's the situation. So that patent monopoly will not be abused. Now let us go to take just a deviation so that we can come back. The deviation is this: patent, like any other property right, patent is a property right, intellectual property right. Patent, like any property right, is transferable. 10 cents of land is transferable, and a mobile property is transferable. Likewise, the intangible property called patent, an intellectual property called patent, is also transferable. Transfers under patent law are of two kinds. The first one is assignment. Assignment is a terminology used for transfer of ownership of patent or intangible property from one person to another. So if I am the patent holder and I'm selling that, transferring that to sufficient, for example, that's an instance of assignment of patent. Assignment of patent will always or usually be, I can say usually be, for a consideration, as we understand in the contract law. Section 2D of contract law defines consideration. So assignment is a complete transfer of ownership. There is another kind of transfer that is known as licensing. Licensing of patent. In a very technical legal sense, licensing is not a transfer. On the contrary, it is just a permission for another party to use my patent right. So as far as my patent is concerned, as we can see on the screen, I've got certain exclusive right like make, use, offer for sale, sell, import, etc. So all or any of these rights for any particular territory or for for the whole world, or a particular stipulated time, or a particular stipulated kind of consideration, maybe royalty or a one-time payment or any of these. So a person will be given a right. If I go to the example of myself and Sufficer, if I'm licensing my patent to Sufficer, Sufficer does not become, please note, Sufficer does not become owner of that patent. The ownership will be vesting with me, and he will be able to use it for a stipulated period under the conditions to what you call to use the patent, activities activities covered under patent law. Okay, so that is a situation where myself and Safi sir is entering into a licensing contract, wherein I will have some benefit and he will have some benefit, and consensus addendum and then consideration and all those free cons and all those consents, all those things will be there. But when it comes to compulsory licensing, this is where we come back to the area we were discussing. When it comes to compulsory licensing, it is also a situation where I will be licensing my right to another person. I will be licensing, I'll be permitting another person to do certain things which is covered by my patent right. But here the notable word is compulsory. When I am compelled, it is not a voluntary license. That's a point I would like to emphasize in today's presentation. It is not a voluntary license, it's a compulsory license. Perhaps I am made to give a license, a permission, without my consent or against my consent. And it is as per the order of a government authority, which is authorized under patent law. So that's the basic idea of compulsory license. And there is only one instance of compulsory licensing in India. Let's have a look at that. So pharma patent is held by a German pharmaceutical giant called, a big pharmaceutical company, multinational company called Bayer AG. And Bayer AG is a German pharmaceutical company, as I said already. And Bayer invented a drug, means a medicine we can take it as, which is known as sorafenib, sorafenib. I'm sorry, I'm not so familiar with pharmaceutical terminologies. So it's science. Yes.
സർ സൗണ്ട് ഇടയ്ക്ക് ബ്രേക്ക് ആവുന്ന പോലെ ഉണ്ട്. നെറ്റ്വർക്ക് ഇഷ്യൂ ആയിരിക്കും.
Okay, but here it appears to be okay. Let me see. Okay. Okay. So that particular drug is known as Nexavar, or that's how it is titled. It is called by that particular company, and that particular drug is used for kidney cancer and also for liver cancer. These drugs can be used for RCC and HCC, which for the purpose of understanding can be understood as kidney cancer and liver cancer. Now, Nexavar is a life-saving drug in a way, but you can also say Nexavar is not a life-saving drug. It is a life-prolonging drug. It won't fully cure the disease, but it will definitely prolong the life of the person, the patient. And the company Bayer, German company, obtained patent in India for Nexavar. And you can see the patent number and the year in which they obtained patent for that. It is 2,15,758 in 2008. And that is known as Nexavar. Now moving on, let us look at the cost of Bayer drug. This particular drug costs how much? That's an important consideration here. The cost of the drug in India for a month treatment, for 1 month treatment, 120 tablets are required, daily 4. In the morning 2, in the evening 2. So 4 into 30, it could be 120. So 120 tablets a month. And the cost of that is, please look at, I strongly invite your attention to this slide. It is 2,80,428. Which means, in other words, one tablet, a single tablet will cost 2,337 rupees. That's the cost of tablet, per tablet, that's the cost. And that's how the Bayer has priced it. Now what happens is, now let's see the other side of the story. NATCO is an Indian company, Hyderabad-based company, to my knowledge. And NATCO proposed to manufacture and then market the drug for rupees 8,800. So as against 2.3 lakh per month, they are going to sell it for 8,800. They offered a fraction, I would say, a fraction of Bayer's cost for a month's therapy. So for if you're going for the same drug under Bayer, then the price is 2 lakhs 3,000. Yeah, more than 3 lakh, 2 lakh 3,000. Here it is 8,000, as low as 8,000. That means as it is 2,000 odd rupees per tablet, here only 74 rupees per tablet. Now what happens is NATCO filed for compulsory license to controller of patent at Indian Patent Office. NATCO applied for a compulsory license to controller of patent at Indian Patent Office. Now let's see, the matter is Bayer versus NATCO. Now the question arises, what is a compulsory license or patent, which I've already put the idea across. And question before the controller of patent, which went up to the Supreme Court. The matter took almost the same line till the Supreme Court. So we'll be discussing only the matter before the controller of patent, because the same line is followed up to Supreme Court of India. Now the question before the patent controller is, can compulsory license be granted? It goes without saying, it's obvious, but that question is to be understood properly. In order to grant a compulsory license, there are certain conditions to be fulfilled as per patent law. The first condition is, one, whether reasonable requirement of the public. Please note, reasonable requirement of the public with respect to the patented invention. Here, in respect to the Nexavar drug of Bayer, has been satisfied. If it is already satisfied by Bayer company, then there is no compulsory license that will be granted. Otherwise, there is a possibility of granting compulsory license. The second question the controller should consider as per patent law, is whether the patented invention is available to the public at a reasonably affordable price. At a reasonably affordable price. Please note. And the third one is whether the patented invention is worked in India or not. Whether it is commercially manufactured and sold in India, because it is patent law. One of the objectives of patent law, as per the patent law itself, is to promote industrial growth. So, if these requirements are not complied with, then there is a possibility of granting compulsory license. Apart from this, it's also stipulated that minimum period of 3 years should have expired after the grant of patent. Minimum 3 years after the grant of patent have expired. Okay. So let's look at each of these questions. How the controller has assessed it, what was the factual situation. First question was with regard to reasonable requirement of the public. Reasonable requirement of the public was between 27,000 to 70,000 boxes. 27,000 to 70,000 boxes. Globocan 2008, a WHO publication, has gone for the study with regard to this. It is as per the requirement, as per the study of WHO publication, that it has been assessed. So patients of kidney cancer 9,000, patients of liver cancer 20,000, total 29,000. So the requirement will be somewhere between 27,000 to 70,000. So that is the reasonable requirement of the public in India at the relevant point of time. Now, the matter to be looked at is important here, the first consideration. There was no manufacturer here, and in 2008, the patented drug was imported to India, and there was as less as, and against minimum of 27,000, only 200 packets were imported in 2009. And in 2010, for 3 years it is, in 2010, So for 3 years, the matter goes like this: whether reasonable requirement of the public was met or not. There was a question. And in 2008, there was no manufacturing here at all. Nothing happened. No, and no, nothing was available for public. Second, as against a minimum of 27,000 boxes, only 200 packets were available in India or made available in India. And in 2010, 60,000, only as less as 60 packets were. Yeah, PPT is not visible. The PPT is, but I'll be explaining this. 60 packets in 2010, and it is available only in metros. Moving to the second question, which controller of patent consider availability to the public at a reasonably affordable price. So whether 2.8 lakhs as much as 3 lakhs per month, is it something which an ordinary Indian, an average Indian, afford in the period of 2009-10, etc. Which means per day, is it possible for a person, for an average Indian, to spend 2,300 rupees per tablet? So the matter is obvious. It says that, or it is understood that only 2%, as less as 2%, only 2% of the relevant public means the potential persons who might go for this, go for the drug. Only 2% of the relevant public could access the drug in the relevant period. Only 2% of the people could access it. It was the price was equal to income of a lower level government employee for 3.5 years at that point of time. So the price here was income of a lower level government employee for 3.5 years. It says it all. So it is not available at an affordable price. And the next question is whether it is worked in the territory of India. Whether it is worked in the territory of India. Even though the patentee had the infrastructure in India, that is, he had all the paraphernalia in India to manufacture the product, they did not do it. So what happens is the patent is being abused. Instead of manufacturing and selling here and helping for commercial exploitation and commercial growth in India, they effectively prevented commercial growth in India. Now even employment generation in India. And what they did is they imported the drug from Germany. So the patentee imported the product from Germany. So there is an abuse of monopoly, and it is not worked in India at all. So on consideration, compulsory license is granted. Compulsory license is granted. The price of the drug, the controller ordered that the price of the drug shall not exceed 8,800 per packet for 120 tablets. So instead of 3 lakhs, it is just 8,000. Even 8,000 is not a small amount, especially for drug for a month. But controller, but comparatively, it is much, much lesser, as you can see it. And the second condition was this: licensee shall pay. So the second, you get to understand how compulsory licensing works. The licensee shall pay royalty at the rate of 6% of the net sales of the drug. So it is not without any consideration that compulsory license is being granted. So a royalty is fixed by controller of patent, which is an authority, a government authority, as per patent law. So it is based on, it was fixed at, royalty is fixed at 6% based on UNDP recommendation in respect of patent, in respect of pharmaceutical products. And the third one is the license is granted solely for the purpose of making, using, offer for sale and selling the drug covered by the patent for the purpose of treating the patients, humans within the territory of India. They cannot make it here and export it to another country. They can use it only for the purpose of patients in India. That was the next condition. Moving further, the license undertook, I would say, it's not an order of controller as such, the licensee undertook to supply covered by the patent. So just look at the social relevance of this. And Bayer was held, or Bayer was given freedom to compete with the licensee and to grant license to third parties to compete with the licensee, which means that Bayer can exist in the market and they can sell it at the price they wanted. So this is not an exclusive license that is granted to NATCO. NATCO can do it and Bayer can do it, or any other person also can do it. But see, this will be a competing situation, and people like you and me will definitely go for, if we are in if you are in need of this, we'll definitely go for. We'll be we'll have the financial wisdom, and we'll definitely go for the NATCO thing, as you get the NATCO thing for much lesser price. And what is the effect of that? The impact of this is this: the price of Cipla's brand, another brand, seeing this, and or rather afraid of this, Cipla's brand Soranib used for HCC and RCC, which means liver cancer and kidney cancer, has come down from 28,000. Please note, 28,000 to 6,000, because they are also playing in the same field and afraid of compulsory licensing, afraid of this legal mechanism and government mechanism. They have slashed their price from 28,000 per month to 6,000. Just see that. And that is a slash of as much as 76%. 76%, please note it. And there is it also impacted the price of many other drugs. I'll just give some one or two examples. Like lung cancer drug molecule is Jeftinib, and its price has come down 59%, and in certain other areas it is as much as 76%. So it has the price has come down like anything. So this is a basic understanding about compulsory licensing, and compulsory license socializes and humanizes patent law and the mechanism, and this is an effective mechanism to prevent or check abuse of patent monopoly, which is integrated, which is written in the patent law itself. So I think we will wind up our discussion on patent for the day, and we will be discussing the matter relating to infringement the next class, and with that possibly we'll be able to wind up our classes on patent, and then we'll see what can be done further. So if you have any doubts, or if you have any clarifications, additions, dissent, or anything of that sort, I'm available now. Otherwise, we will call it a day.
Different news reported in the Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional